On the record in People versus Caleb Clock, file number 255442. The record should reflect Mr. Clock present here in the courtroom today. If I could have counsel make your appearances on in this case.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Caleb Clock. Sorry, Your Honor. I'm going through my files. It's the sheet on this. If the prosecutor could state the plea for the record.
Your Honor, this is a violation hearing.
Yeah.
The underlying case that's the basis for this violation is still pending in district court. He's not scheduled for his preliminary exam until January 13th. He does have a probable cause hearing next week. I would just recommend an adjourning violation.
I'm sorry, that's correct, Your Honor. Yes, Mr. Clock would intend to enter the plea in district court when that's up. So we'd ask to adjourn that until that.
Okay. Mr. Clock, do you have any questions about how to proceed in this case?
I just have one thing. The preliminary exam got changed to the 27th of January.
Okay.
I have paperwork for it.
All right, so we'll set this for a hearing in February.
Yeah,
I suspect we'll be before the court sooner than that on sentencing. So maybe we can address it.
Okay. All right. So I'll just set this for a hearing on the same date as the sentencing hearing once that's set.
Okay.
All right, thank you.
Thank you, Mr. Clock. That's all for today. Mr. Lewis, if you'd like to come forward, please. We'll go on the record in Chico versus Eric Lewis, file number 255493. The record should reflect Mr. Lewis is present here in the courtroom today. Counsel, how did we want to proceed on this case? What's the status?
Your Honor, there is a plea offer at this point. It's not the original plea offer because the defendant ran the prelim, but the current offer would be that if Mr. Lewis pled to 2 counts of R&O as a hab second, which would make them regular offenses, the prosecutor would dismiss counts 3 and 4 and the additional potential habitual status offenses.
Scope, is that a correct statement of the offer?
It is.
Mr. Lewis, have you had an opportunity to speak with Mr. Thompson about the plea offer?
Yeah.
Do you know whether you would like to accept that plea offer?
Can I ask a couple questions real quick before I accept or deny or whatever?
Sure.
One is, am I looking at jail time or prison time? Can I know like a time frame reference? I don't care, ballpark, anything like that, jail or prison, it doesn't matter.
Mr. Thompson, would you run any?
No, I know the guidelines, Your Honor.
Oh.
You know what I mean? The guidelines should be like 5 to 24 or something like that. But I'm actually trying to seek help, like, like rehabilitation services of some kind, whether for drug or alcohol. I just did a long time in prison, so I feel like maybe like some type of break me back down to society thing would be more beneficial than going back to prison due to me, the circumstances of prison, alone and how long I just did or whatever. So I'm seeking something like that, you know what I mean? And the second thing I would like to say is during the prelim, it's not on the record or the docket why it was adjourned, and per law and policy that they're supposed to put that on the docket, and they went past my time frame for the prelim. It doesn't matter how it's added up. They have 7 to 14 days to hear me on the probable cause, and then 5 to 7 to hear me on the prelim, and they went past that.
Okay.
So I don't know if that affects anything. I know due to law that's supposed to be taken into account. I was supposed to be given the Weston remedy due to that, and I was not given anything. I was just denied everything in court.
You're supposed to be given what?
The Weston remedy,
What's that?
where dismissal or dropped in misdemeanor charges, Your Honor. This is in People versus Crawford, People versus Weston.
Okay. If they miss a date, you just everything just gets dismissed.
No, no, it's up to the court's discretion on whether it gets dismissed or it gets dropped down to misdemeanors. And that's everything I've read, and that's as of 2025 law that's on our little computers in the thing. I just wanted to bring that up.
Well, maybe you have an argument. I don't know whether those cases are applicable here or not. So I guess you got two questions here. Number one, your question about the sentencing. I don't really know anything about you. I don't know anything about your circumstances. I don't know anything about the facts of what happened in this crime. If you were to plead guilty today, you've been through the process, it sounds like. So we would have a pre-sentence report where I would get all that information about you, your background, your past criminal history, what happened in this case, all of those different types of things, the guidelines. That all goes into my decision about what's an appropriate sentence. So sitting here today, I don't have any clue whether probation, local jail time, prison, which one of those options would be appropriate. So I cannot tell you what your sentence would be today, other than it would most likely be within the guidelines. In terms of I can't make a ruling today about the effect of any delay of your prelim. If you want to challenge that, you absolutely have the right to do that. You would need to do that either through your attorney or if we're going to waive counsel. But in any case, if you wanted to challenge that, if you believe that you're entitled to a reduction in charge or a dismissal of charge because of something that happened in district court, that would need to be filed as a motion. I would need to hear that motion and make a decision about that. I can't just off the cuff make a decision here today.
So one more question. You guys, I haven't been in court in a very long time. You know what I mean? And I don't really know nothing about like these type of proceedings, but they don't offer like a county cap no more.
That's up to the prosecutor. I mean, I don't get involved in sentencing negotiations.
Oh, right. Well, my lawyer told me that the courts don't even offer county caps anymore.
I never offered a county cap. That was never anything.
No, I'm saying he's basically saying like they don't even do that in courtrooms anymore. Any type of county cap. The last time I was in court was like 2014 or something like that. And you could get county caps in that year. You know what I mean?
I don't know
And since
what
COVID, a lot of things have changed. That's why I was asking.
I don't know what you mean by they. You say they.
Just courts in general. Courts don't offer caps no more, I guess. That's the basic question.
I've been a judge since 2013. I've never heard of a court having a policy of some kind of county cap.
I mean, I don't think it's policy. I don't really know if it's a policy or any type of law, but I've got a 12-month county cap before. That's why I asked. You know what I mean?
To me, that's something that would be negotiated between you and the lawyers or the prosecutor. I don't have a agreed.
I don't want to plead guilty, but I'll plead no contest.
Oh,
I don't have an objection to that, but I don't have a police report. If the court hasn't in the file, the court could use that and I would not object. I believe it meets the elements if the court wants to review it.
were you intoxicated when this happened?
No, I was off my meds and I was sick and I was on like NyQuil and Dayquil and stuff like that. And like, I really don't have any proof of this besides being sick when I came to the county jail. Like, I really wasn't in the right state of mind when all this happened.
Your Honor, I have a file copy of the police report. I would ask if I could give it to the court can review it for sufficiency, but ultimately that one without my notes on it be memorialized in the court file.
I have a blank one.
Oh, I'd ask the court to use Mr. Havens if that's possible. Thank you.
You know, you can tell that like I wasn't in the right state of mind by a couple of the statements. One, they told me to sit in a chair, and for some reason I didn't understand, or I thought it was a typo when I first read it, where not to cuss in the courtroom where it says I ain't saying shit. I didn't even know they actually told me to sit in a chair. So like I said, when I read the police report, I'm like, what? That don't even make sense. But apparently I really did say that. So that's, you know what I mean? That goes to my state of mind. Like, it don't even make sense why I would say that because I've been cooperative up to that point. And then another thing, I didn't even know what day it was.
Okay.
You know what I mean? Like,
Well, I think all of that would provide a basis for no contest plea in this code. Would you agree?
I would agree.
All right, so
If the court's satisfied, I don't have anything.
no, I think I'm satisfied. There's a basis for no contest. So, all right. So you wanted to go forward with that plea agreement today then?
yes, Your Honor, I'll go forward with it.
You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
Thank you. Are you currently on any kind of probation or parole?
I'm on parole currently.
Okay. So you understand that any sentence that you would receive in this case would be served consecutively, in other words, back to back with the parole violation?
Yes, I understand this.
And you also understand that you would not be entitled to any jail credit with your parole status.
Yes, I understand.
And by pleading guilty to resisting or obstructing as a second habitual offender, the maximum penalty that you could face for each of those charges would be up to 3 years. You understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to those 2 charges today?
No contest.
Now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court or any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights,
Yes, Your Honor.
and you understand that you're giving up and waiving all of those rights by pleading no contest.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you can only do that by leave. That means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
Just threatened basically for prison time.
You've been advised of the consequences.
No, basically I was told I was getting prison no matter what happens in this situation.
Are you, all right.
Mr. Lewis, are you referring to legal advice about possible sentences the judge might give?
When I talk to him about anything, he says that this would normally be like a 90-day type thing or whatever in a county jail. All he does is basically tell me that the whole courtroom and everybody just wants me to go to prison. So I'm just ready to get it over with and get going.
Okay. So it's Mr. Thompson's job to tell you what he thinks the likely outcome of your case is, right?
Yeah, he's basically like, it doesn't matter what the outcome is, what the pleas get dropped to, it doesn't matter. So,
Okay.
yeah,
Wouldn't you want him to tell you what the worst case scenario is?
I mean, it
Fully
just-
Understand?
yeah, I mean, yeah, I understand that, but it just doesn't make sense. You got people in the county jail with drug charges, massive amounts of drug charges, gun charges, which is a mandatory 2 minimum, and all types of other things that are getting county jail time. You know what I'm saying? I know somebody that just got caught with 2 ounces of meth and has a rap record longer than mine, and he's a known drug dealer, and he just got 7 months in the county jail for 2 ounces of meth and just nothing. You know what I mean? Like, so I know, like, if he's saying that, then, you know what I mean? Like, basically, I feel like, I mean, I ain't got no other choice. It doesn't matter if I go to trial or not. And I know you guys might not understand a lot of things about prison, but I'm gonna get a flop regardless because of the level I'm going to and the things I'm gonna be end up going back to. So it doesn't matter. It doesn't matter.
Okay. All right. Has anybody promised you anything other than what we said here in court today?
No,
Is it your own free choice to enter this plea?
I mean, yeah, I guess, yeah.
Okay, well, I don't want you to guess. It either is or it's not.
I mean, yeah, it is.
Okay. All right. Ms. Koch, have you reviewed, and I'm going to refer to Crawford County Sheriff's Department, report number 2512733. Have you reviewed that report?
Yes,
Do you agree that the information contained within that report would provide a factual basis for a finding that Mr. Lewis is guilty of 2 counts of resisting or obstructing a police officer?
yes,
Mr. Thompson, have you reviewed that report as well?
I have.
Do you agree with the factual basis?
I agree it provides a sufficient factual basis, Your Honor.
I need to read through this for a second. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record here today?
No,
Mr. Thompson?
No,
Ms. Koch, are the people satisfied that the court has complied with statute before going and taking of this non-contest?
yes, Your Honor.
Mr. Thompson?
yes,
All right, Mr. Lewis, the court finds that your plea is knowing, voluntary. I'm going to mark and admit that police report that I previously identified as Court Exhibit 1. I've reviewed that. The court finds that the information contained within that report would support a finding that you are guilty of 2 counts of resisting or obstructing. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You'll meet with Gauthier.
Mr. Haven.
Meet with Mr. Haven for a pre-sentence report. You'll have a chance to review that and go through that with your attorney before the
Sentencing. Your Honor, may I ask what two, I guess, what 2 times am I pleading guilty to?
Well, you pled no contest.
No, I understand that, Your Honor, but I'm pleading guilty to 2 counts. I mean, does it matter? Does it matter what counts, or like, is there specific counts that I'm pleading guilty to?
You're pleading again, you didn't plead guilty.
No, I mean, no contest. I mean, is there 2 specific times in the police report
Counts
to which
1
I'm,
and 2,
which I'm actually pleading guilty to?
your support, you pled no contest, the court is finding you guilty of resisting or obstructing with regard to Deputy Clark.
Okay. Thank you, Your Honor.